Welcome to the daily YouTube session. The topic that we will be discussing today is what are the ambiguities in the India's nuclear liability law. I assume that majority of the students would have read this article. It becomes significant for your prelims examination as well as your mains examination, because the question as it's in itself can be asked with respect to the mains paper and the location of nuclear plants, and something with technology of the nuclear plants can be asked with respect to the prelims examination. So, we first of all we will try to highlight that what the article is talking about. The article has a premise of something that is called as nuclear liability, and in this context article states about India's nuclear liability law and what are the issues with respect to this. So, first of all we need to be very clear that what is nuclear liability, as this kind of scenario has basically hindered the development of Maharashtra's Jaitpur nuclear power plant. So, first of all, what is nuclear liability? We need to understand this term. It is a technical term. So, it refers to the legal responsibility of an operator or supplier of a nuclear facility for any damage or injuries caused as a result of a nuclear incident. The 2 to 3 things that you need to work upon here is, first of all, the liability is legal in nature. Second thing, it is imposed upon 2 individuals. One is operator who is operating the nuclear plant, and the supplier as well who is supplying material with respect to the nuclear power plant. And if a damage or a nuclear incident occurs with respect to a nuclear site, then they have a legal responsibility to compensate the victims. So, what can be the nature of liability? We also need to understand basically what sort of liability does the operators or the suppliers have. See, it includes, first of all, it includes compensation for loss of life. Second thing, it can cause, basically the liability can be caused with respect to the personal injury. For example, a person has become disabled because of this incident, then the liability with respect to the property damage that has been done because of an incident at a nuclear site. Then at last it is a issue with respect to environmental damage also, because the incident will create some environmental problems that will be hindrance for the sustainable development as well as environmental conservation and preservation. So, that is the nature of liability here, as the release of the radioactive, the technical term here again, the release of the radio material or the occurrence of a nuclear accident can cause these type of instances to happen, and this will create liability on the operator or on the supplier. So, next, why this news is in basically of significance, we have already in our last slide we have seen that India's nuclear liability law is creating a hindrance for the more than decade old plant to build 6 nuclear reactors in Maharashtra's Jaitpur area. So, first of all we need to know what is nuclear liability law that has been put in place by the India. Next, we need to know what are the issues with respect to this, that it is creating a hindrance with respect to the development of this plant. So, first of all, let us come to the feature part. See, India's civil liability, as you can see, Civil Liability for Nuclear Damage Act, it was passed in year 2010, and for what purposes? To establish a legal framework. Again, the word is important that can be asked with respect to your prelims examination. Legal framework addressing liability as well as compensation in the event of nuclear accident. So, what is the basic objective of here of nuclear liability law is establishing a legal framework in case of nuclear accident. Further, the act outlines the responsibility. See, that again the term is very important. Responsibility of whom? Plant operators, those who are operating the plant, obviously, suppliers who are supplying the material, and the government as well. And the government ensuring prompt and fair compensation for affected individuals and communities. Now, what you can see from here is that nuclear liability law works upon 2 to 3 things. One of them is legal framework that you have in place, then the who are the individuals on or entities upon whom liability has been imposed, that is government, second one is basically operator, and third one is your supplier. So that it is the responsibility of these entities that if an incident has happened, they should provide prompt and fair compensation to the affected individuals. See, next you will need to know there are some key provisions of the act. First, for example, first one is operator liability. The first issue that you have at hand is operator liability. First provision, what does it talk about? The act designates the nuclear plant operator as the primary entity. Again, the term is important, that those individual or the entity who is operating the nuclear facility, that entity is the primary entity that is responsible for compensating victims in case of nuclear accident. This strict liability means that operator is liable regardless of whether they were at fault or not. Very important point with respect to your prelims examination. The thing can be asked like this only, that whether the nuclear operator has a liability. Okay, when the individual who is at, or the entity who is at fault may be the supplier because they supplied the defective material, but again government has stated that the individual operator will remain the primary entity for compensating the victims. Next, government has placed a financial cap on liability. What is a cap? It sets a financial cap. The individual or the entity who is operating the nuclear power plant, they have a cap that they will compensate for up to the amount of rupees 1500 crores for each incident. That is basically what needs to be understood here. Then the second thing that you need to say is that if the compensation raises or exceeds this cap, then the remaining will be provided by the government, and that to the amount, there is a cap with respect to the 300 million special drawing rights, or what is considered approximately as 3300 crore. So what we need to understand here is 3 things. The operator's liability remains whether they are at fault or not. First point can be asked with respect to your prelims examination. Second point that can be asked with respect to the prelims examination is there a financial cap on the liability? Then it is yes, it is up to 1500 crores for each nuclear incident, and the remaining has to be compensated by the government of India up to the limit of rupees 3300 crore. There is also a financial cap with respect to how much the government will compensate. Now moving forward, what are the other basically provisions of this act? Another provision is there is a claims commission that has been established by the government. The act provides for the establishment of a nuclear damage claims commission. Nuclear damage claims commission to adjudicate means to solve or address all the claims that are resulting from nuclear accident. So some sort of what we can say institutional framework has also been established. First point. Next, so that victims have a faith in administrative efficiency and in the government, the law states that for compensating the individual there should be a time limit. It sets a time limit that if you are affected by the nuclear accident, you have to present the claims related to, for example, personal injury or death must be filed within 20 years of the nuclear incident, whereas the claims for damage to property must be filed within the 10 years. There is no uniformity, there is a different sections for different things. If your personal liability or death is personal injury or death is there, then the time limit is 20 years, whereas if the damage to property has been done, then you have to file the complaint within 10 years. Then last here is right of recourse, the very important and very contentious issue. The act addresses supplier liability in section 17, which grants operator a right of recourse under the supplier under certain conditions. It means that if a nuclear incident has taken place, then the operator, if in case of basically supply of defective material or basically of lower quality, they can file a case against the supplier that it is their fault that they have basically caused the nuclear incident. So they can also approach the court, but it will be done by the operator in case of the basically supplier supplies defective or lower quality material, but again the primary responsibility of compensating the victims is of nuclear operator. Then last clause here is mandatory insurance. The act requires nuclear power operators to obtain insurance or financial security to cover their liability, so that they do not go bankrupt and they have basically funds, adequate funds in case of incident, so that they can compensate the victim immediately. So what are the points here? It provides for an institutional framework, then there is a time limit with respect to filing the claims, and there is a right of recourse that is to be used by the nuclear operator against the supplier in case of defective material or material of lower quality. And then there is the issue of mandatory insurance that provides financial security in case of incident, so that the compensation can be provided. See, next is what are the issues with respect to this law, so that it is hindering the development of a nuclear power plant in Jaipur. First of all, issue is inadequate liability cap for operators. See, what is the issue here? The liability cap on an operator may not be sufficient to compensate the victims in the event of major nuclear disaster. For example, at the international level, there was Chernobyl, then we have not a related incident that is called as Bhopal gas tragedy. Okay, if a scale of an incident, of a nuclear incident is very large, the cap of 1500 crores may not be sufficient to compensate the victims, and it is less when compared to the other countries. So that is what first of the major issues with respect to this law. Second is of potential conflict of interest. What is the issue here? We have already seen that the individual on whom liability is imposed, that is supplier, operator and the government, but sometimes the government in partnership with private entities operate a nuclear power plant. So the government is also responsible for notifying the extent of environmental damage and economic loss. When the government is itself the perpetrator, or if it is itself the what we say nuclear operator, how they are to basically compensate the victims, because it is the government entity that will also decide what kind of loss has happened, what kind of damage has happened, and what should be the extent of compensation that should be given to the victim. So it presents a situation of conflict of interest, as where government is also a party to liable to pay compensation. Second point. Now third point is basically it is in non-compliance with the international agreements. How? For example, the right of recourse against the supplier provided under the act may not be compliant with the international agreements that the India may wish to sign. It may state that basically international violations or the provisions of the international agreements are not being specifically adhered to, and specifically in the case of right of recourse against the supplier. Then there is a limited time frame for compensation claims, as we have already seen that in case of personal injury, then the or death, the time limit of filing a case is what 20 years, and in the case of property damage it is 10 years, but it is stated that the 10-year limit for compensation may be inadequate from those suffering from nuclear damage, because they may not have that kind of reactions or adverse consequences from the nuclear damage in that particular time period. They may develop that signs or reactions or adverse consequences from radioactive material after some point of time. Okay, so that creates another issue. Then there is ambiguity in applicable laws. Why? The act allows operators and suppliers to be liable under other laws, but it is not clear which specific laws apply. There is basically you can hold liable operators as well suppliers, you can reach the court and make them hold liable under many laws, but it has not been clearly defined that if you want to approach the court, which specific laws will apply. So what happens is that different interpretations by court could either expand the basically what we say scope of such a act, or either may constrain the scope of the subject of the law, leading to inconsistencies in application of liabilities laws. This creates a very poor business environment. Why? Because the individuals who want to invest and establish a nuclear power plant here, they will read the provision that yes, we can be held liable under other laws, but under which laws? That is not specified. Further, it gives the discretion to the court to expand the scope of the act or to constrict the scope of the act, that depends upon the interpretation by the court. So it creates very inconsistent situation for the business environment. So what we have learned, the issues: inadequate liability, conflict of interest, then non-compliance with the international agreements, limited time frame, and ambiguity in applicable laws. Further, we need to also see how this particular situation can be improved. There are issues and we want this kind of things should not happen. Okay, we want to review the construction work or with respect to the Jaipur Maharashtra power plant, nuclear power plant. So these kind of incidents do not happen. What we need to do? First of all, we need to review the liability caps, reevaluate the current liability caps for operators and suppliers to determine, to see whether they are adequate to cover the potential damage or not. That was our first issue also with respect to this particular act. Then we need to enhance regulatory oversight. It means we need to strengthen our institutional mechanisms. For example, strengthen the role of regulatory bodies such as Atomic Energy Regulatory Board to ensure strict compliance with safety standards and guidelines, so that nuclear incidents do not happen and it does not create a bad environment for investment, as well as should not create a fear in the minds of people. Next, what you need to do is with respect to international cooperation. India should actively engage in international forums and work with other countries to share best practices, technical expertise, and strategies to address nuclear liability laws. What is happening at the international level, how the countries are coping up with these mechanisms, how they are improving their safety standards, what kind of expertise are they basically involving, what kind of liability mechanisms are there, that should also be followed by India. And at last is to increase the public interest, to increase the public trust and safety, as well as to remove the fear of this particular type of incidents. We should do is increase transparency in what we say nuclear sector and enhance public awareness about nuclear liability, safety measures, and emergency preparedness plans. We need to assure the public that every safety standard has been put in plan, our regulatory mechanisms are fine, what kind of expertise are we involving, transparency in the functioning or the oversight mechanisms that are used by the government, so that people can be assured and their level of trust can be maintained. So what we have discussed, first of all, we discussed what is nuclear liability, then we discussed what are the issues, what are the provisions of nuclear liability law in the context of India, then what are the issues with respect to that law, and at last how these issues can be solved. So this was our topic for today, and we will also do one prelims question that is can be asked with respect to your prelims examination. First one is Jaipur nuclear power plant is in Maharashtra, second one is Kaiga nuclear power plant is in Karnataka, and third one Narora atomic power station is in Uttar Pradesh. If you have read the news, you may see that this one is already correct because this thing was covered in the article. So at least one of them is, what are the options? One of them is correct, two of them are correct, three of them are correct, or sorry, this is a mistake here, it should be none of the above are correct. So what can be done? We know basically about one thing. Now if you have revised properly this topic, you will see that Kaiga nuclear power plant is in Karnataka, and another thing for way for learning here is K for Kaiga and K for Karnataka, you will remember this. Then there is Narora atomic power station, and this is in Uttar Pradesh, this is also correct, and here three of them are correct, all the basically things are matched correctly. So this was all from my side for today. Thank you.